Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer some frequently asked questions about Illinois probate. Probate is a court case where the court oversees the distribution of a deceased person's assets to creditors and heirs. So a lot of people don't know how probate works, so we're just going to run through 5 or so questions that we get asked a lot. First question is, when is probate required? Obviously, you don't want to go through a court case if it's not required, and it's not always required. Basically, the rule of thumb is for small estates, you don't have to go through probate. You can just administer the estate outside of court. So what's a small estate? It's kind of a deceiving term because anyone who has a proper estate plan, no matter how large their estate is, can probably avoid probate. Basically, whenever you own any real estate outside of a trust or more than $100,000 outside of a trust or outside of payable on death accounts, probate is required. So what a lot of people will do is they'll get an estate plan put together and transfer their real estate and everything over $100,000 into a trust. And anyone who's got a good estate plan probably shouldn't be going through a probate estate, or whoever's done it properly. Also, people without real estate or with less than $100,000, when they pass away, they don't need a probate estate. Instead, what their executor will do is go to the probate court's website, download a one-page form called the Small Estate Affidavit, and fill that form out. The form basically says there's no real estate outside of the trust, there's less than $100,000 outside of the trust. I am I'm the executor or trustee appointed by the will or the trust, and therefore I have the authority to administer this estate outside of probate. So with that affidavit and a copy of the will or the trust and the death certificate, they can then administer the estate outside of a probate case. But probate is required. It's the only way that the executor can get the authority to assemble these assets and then liquidate them and transmit them to the heirs and creditors if there's more than $100,000 or any real estate outside of a trust in the estate. So the second question people ask often is, do I need an attorney to handle a probate estate? The answer is yes and no. You don't need an attorney ever for anything. So in almost every circumstance, you can do anything on your own. Just like I can fix my basement on my own. It's just a matter of how much extra expense and time is it going to take. There's a lot of good reasons to have an attorney to handle a probate case. We have a video, a podcast, an article on that subject. If you go to learn-about-law.com, we detail the reasons that it makes sense. But the bottom line is it'll save you time, money, liability, and it'll make the probate case a little bit quicker, well, a lot quicker if you have an attorney. It's pretty complicated. There's a lot of deadlines and notices, so we always recommend, if you have to go through probate, get an attorney. If you don't have to go through probate and you're administering the case through a small estate affidavit, you can often get away without having an attorney. A lot of times when people call us about that, we'll say, here's where you can find the affidavit. You can give a crack at filling it out and administering it on your own. If you need us, call. It's not very expensive. But administering an estate out of probate is something that you may want to have an attorney just consult you on rather than handle the entire process. Question number 3 is, what is a probate bond? This is a good question. A probate bond is basically insurance that you as the executor are not going to screw up the handling of the estate. So there's 2 types of bonds. There's a non-surety bond, and that is just the executor's personal guarantee that if they pay out the wrong people or distribute the estate incorrectly, that they're going to be personally liable. The other type of bond is a surety bond, and this is something that you get from an insurance company. In exchange for an annual premium, the insurance company will guarantee up to 2.5 times the value of the estate, and if there's any errors, the insurance bond covers it. It doesn't come out of the executor's personal assets. Usually insurance companies require that you have an attorney if they're going to insure you through a surety bond. Bonds aren't always required. They're generally required unless they are waived by the will, so that's a good reason to have a will if you don't want your executor to have to pay a bond, or if they're allowed not to be had through a petition to the court. But generally, you have to get either a surety or a non-surety bond, and sometimes it's up to the executor, sometimes it's up to the will, sometimes it's up to the court what type of bond you get. All right, question number 4. What happens if the deceased individual owned real estate in multiple states? In this case, wherever they resided, if they also owned real estate in that state, you'll open up a primary probate estate. and that's where you'll deal with all of their non-real estate assets and whatever real estate they owned in that state. But if they own real estate in a second or third state, then you have to open up probate estates in those states just to deal with the real estate. Now, again, if the real estate is all owned in a trust, going back to question 1, if they set up their estate plan correctly, probate might not be necessary. If they don't do it correctly, that can be a real headache, because now the executor has to deal with probate in 2 or 3 different states, 2 or 3 different court cases. It's twice or 3 times as expensive, and it's a major headache. So, the lesson there is, especially if you own real estate in multiple states, you should definitely talk to an attorney and get an estate plan so that your executor doesn't have to deal with 2 or 3 concurrent probate estates. Last question is, what should you do with a will if you're the executor? It's pretty easy. You have 30 days to file it in the appropriate county where probate is required. So that's the county where they reside. So what you do is find the original of the will if you can't. If you can't, take a copy. If you're going to hire an attorney, just bring it to the attorney. They'll file it. Otherwise, you can go to the county clerk's office and they can help you file the will. But as the executor, you have a duty to make your best efforts to file the will within 30 days in the appropriate county. So thanks so much for listening. If you have any other questions, you can comment on our page. And call us at 630-324-6666 for a free consultation.